Hey everybody, this is Christopher Small from CMS Law Firm, and today I want to talk to you about how to give money to your kids, particularly your young kids, and particularly if you know you're ready to get rid of this money, okay? We're not talking about leaving it via a will or anything like that, how to give it to them after you die. We're talking about you're alive, they're alive, you got some extra scratch, and you want to give it to them now so that it's not part of your estate, basically. Before I get to that though, if you don't know what a will does, if you don't know what a trust does, if you don't know what a power of attorney does, I've created a little video at estateplanningvideo.com that sort of outlines the basics. So if you want to get a crash course in estate planning, go there, check it out. It's free. It's about 20 minutes. Talk to you about the benefits and the not consequences, but the downside of what all these documents can do and not do, so that you can learn a little bit more about estate planning and attack this area of your life with some knowledge. All right, but today I wanted to talk to you about how to give money to your kids if you've got some, like I said, some extra money to give that you don't want to get back. Okay, because that's the key, or the strategy that we're talking about right now, is that you're not going to be able to get it back. Okay, with the things I'm going to tell you. So first things first, what you need to know is that I got to start at the top real quick. So at the top of the line, federally, we have an estate tax exemption of $11 million per person, okay, and some change. If you are married, essentially it's $22 million before you have to start paying any estate taxes, okay? Now, you can give that $11 million away when you die, or you can give that $11 million away while you're alive. Okay, that's step one. Step two, Washington State has its own estate tax. That estate tax starts at $2.5 million, and if you are married, there is no, and it's 2.4 and change. There is no portability, is what this is called. So you can't just go to 5 million if you're married, but there are some things that you can do to go from 2.5 to 5 if you are married in Washington State, to sort of double your estate tax exemption. All right. Now, with that being said, the federal level, okay, so I'm jumping around here slightly, but I have to. In Washington State, all right, you have this estate tax exemption amount of $2.5 million, but there is no gift tax in Washington State. That means you can give as much money away to anybody that you want at any time without having to worry about the Washington State estate tax. Fair? Federally, they do have a gift tax, which is the same amount as the estate tax. So if you give over $11 million in your lifetime, you're going to start to pay tax on that, okay? On top of that, the federales, I don't know what I was going to call those people just now, the federal government allows you to give $15,000 to as many different people as you want every year without chipping in to that $11.2 million exemption every year, okay? So you don't have to worry about that if you are within that $15,000 period. If you're married, it can be $30,000. So $15,000 for each of you to each person. All right, confused enough yet? So this all comes into play because I had a client send me an email this morning that said, hey, we just had a baby. And I said, hey, congratulations, that's amazing. And they wanted to know, can we give some money to the baby? They're creating a trust. They want to know if they can put this money in the trust and set it aside for the kid now. And that's what I want to talk about. Okay, what do you want to do if you're in that situation? So there are a couple of different options, depending on where you're at on your asset level. So if you are nowhere near $11 million, or if you're married and you're nowhere near $20 million, $22 million, I probably wouldn't necessarily care about the estate tax or the gift tax exemption federally. Okay, the only thing that happens is if you go over that $15,000 in a year, which they would by 20,000. So mom gives 15,000, dad gives 15,000, they're at 30,000, and they want to give 20 more. All they're going to do is next year when they file their taxes, they're going to check a box and they're going to say, we gave away 20,000 extra dollars, and it's going to just reduce that $11 million by $10,000. Okay? Are you confused yet? Hopefully not. I need a whiteboard for this one. maybe. But they can do that, okay? That's step one. The step two, though, is where are you going to put this at? What are you going to do with it? If you have a revocable living trust, you could, I guess, put it in a separate account and just have it held in the trust. But the reality is, for the world, including the government, they're still going to see that as your own money until you die. Okay? Because if you own a revocable living trust and you are the trustee and the beneficiary, if you are everything, then everything that the trust owns while you're alive is still yours. Okay? That's why you don't have to have a separate employment identification number. You don't have to file separate taxes. It's because everything is yours. So the other thing you have to consider is what do you want to do with this? Do you want this to become a lot bigger than the money that you're putting in? Do you want to have it grow steadily over time? One of the things that you could do in this example is you could buy a life insurance policy on yourself, on dad, for example, or on mom, and you could make it a whole life policy. Okay, that means it grows over time, doesn't have a term where it runs out. You take this life insurance policy, you put it into an irrevocable trust. What that means is you cannot revoke the trust, basically. What this does is it gets anything that's in that trust would be out of the estate of the two parents, okay? You plop this life insurance policy in there, and then you start feeding this money into this life insurance policy, okay? If you live a long time, you'll just keep accumulating cash in there, and when you die, then your kid or your kids will have this money in this trust to work with. If you die early, you get the death benefit from that policy, and you just tripled, quadrupled, 10x'd the money that you've actually put into the trust. But at the end of the day, what's happened is you've moved that money out. Okay. Another thing that you could do is you could literally just open a bank account in the name of your kid. You could just move money over there. Keep track of what you move over. If you want to gift more than 30 grand if you're married in a year, then you want to make sure you file on the taxes. But you can do that. My recommendation, or my strong consideration, I guess, would be the revocable life insurance trust. Irrevocable life insurance trust. It's called an ILIT, I-L-I-T. Because you get the best of both worlds, right? You get quick growth because of the life insurance policy, the death benefit. It's outside of your estate, so whatever you put in actually leaves your estate and receives some additional benefit, and it's there for the kids when they need it. Okay? So that's it. That's just one. There are other strategies you can employ. I'm going to hop on real quick, though, not take too long, get too complicated, and sort of lay that out for you. All right? So if you have questions about that, feel free to email me, comment, message me, whatever you want. Feel free to leave a comment. Share this with people if they need to hear it. Like it if you like it. And if you want to get the basics, go to estateplanningvideo.com. All right? That is it. Christopher Small with CMS Law Firm. Thank you so much for listening, and I will be here again to talk to you tomorrow. Bye.